Welcome back, guys. Let's discuss Ripple versus SEC lawsuit update. Deaton dismisses settlement rumors with the CS in the middle of the SEC's motion to compel financial statements. A Project RP attorney named John Deaton recently presented a live webcast in which he refuted rumors that settlement talks are now taking place between the SEC and Ripple in his description of the ongoing legal processes. Deaton referred to it as scorched earth litigation. There is no discussion of a settlement. Attorney Deaton has indicated unequivocally that there are currently no continuing conversations regarding a settlement between the Securities and Exchange Commission issue in Ripple. The recent motion that was submitted by the SEC, which requested that Ripple present audited financial accounts for the period of 2022 to 2023, as well as post-complaint contracts that oversee institutional transactions, served as the basis for this declaration. What comes next for those who own XRP? Deaton gave the following statement on February 1, 2024. I do not believe there are any talks for a settlement. The intensity of the ongoing legal battle is highlighted by the fact that this litigation is still being fought to the death, even though it is in the remedy stage. A potential settlement in the not too distant future. In the course of their conversation, Deaton revealed his opinions about the possibility of a settlement in the future. While he is now stating that there are no discussions taking place, he is of the opinion that a settlement may take place in the future. According to Deaton, the Securities and Exchange Commissions may be interested in reaching a settlement if they believe they will be able to obtain more favorable terms than what a court ruling may bring about. He made the following statement. Perhaps that will convince them to come to the table because they have the ability to spin it, as opposed to getting another ruling that embarrasses them as an organization. I'm not denying that a settlement is possible or will take place. I just wanted to let you know that it is not going to happen today as a result. There is a possibility that an agreement will be reached, but at the moment that is not taking place. Comprehending the fines and other legal matters as the action moves further into the remedy stage, there is discussion around the potential sanctions that Ripple would be subjected to for claimed violations. Connected to institutional sales, Deaton mentioned that the Securities and Exchange Commission, that Sky, is interested in Ripple's financial records and is investigating contracts that were made after the complaint was filed. According to Deaton, Ripple may demonstrate that the majority of institutional purchases are acceptable, and the cost of the fine may range anywhere from $10 million to $100, according to Ripple CEO Brad Garlinghouse. He made the observation that Ripple would end up paying considerably less in fines than the significant amount of money that they spent on lawyers to defend themselves, which was approximately $200, taking a look past the decision. Deaton's viewpoint extends beyond the existing trial and investigates the potential outcomes that could occur in the event that an appeal is filed. He is fairly confident that the Two Circuit Court of Appeals, which is a higher court, will agree with Judge and Alisa Torres' decision to dismiss the case for early termination. It was brought to Deaton's attention that Torres has made some very significant decisions with regard to programmatic sales and the distribution of XRP funds, although there may be an attempt to challenge these verdicts. He is of the opinion that they will most likely be up. One of the legal issues that is being closely followed in the cryptocurrency business is the continuing case that is being brought against Ripple Labs by the United States Securities and Exchange Commission. It is important to keep in mind that the Securities and Exchange Commission set asserts that XRP is in essence a security, and that Ripple has carried out a huge security offering without registering it. As such, Ripple appears to be prevailing over the situation so far, despite the fact that the case has been through a number of highs and lows during its course, considering that it was able to achieve a number of victories in 2023, particularly when the judge who was presiding over the case and Alisa Torres decided that XRP that was sold on secondary markets did not constitute investment contract. On the other hand, there is a new development that is most likely to occur in the near future. And according to one attorney, Judge Torres is required to make a decision on a particular motion in a reasonably short amount of time. During the month of January, the commission submitted a move against Ripple in which it demanded that the business deliver specific papers that are associated with the proposed case. In essence, they requested that the court compel Ripple to comply with the terms. Shortly after that, the corporation responded requesting that the deadline be extended for an additional period of time. Once the back and forth is concluded, Judge Torres will be required to make a decision regarding the order to compel by the 12th of February. That is the opinion of Bill Morgan, who is a lawyer at the very least. This was brought to the attention of X by the legal expert, who stated it would appear that judge needs to make a decision on the SEC's request to compel as soon as possible, given that the present timetable for the remedies phase demands that completion of remedies related to discovery be finished by February 12th. In any event, the trial between the two parties is planned to begin later in the year 2024, specifically on April 23rd. And it is really intriguing to speculate on the manner in which the legal dispute will be resolved. In the meantime, if you are interested in learning more about some intriguing forecasts regarding the price of XRP in 2024, take a look at our most recent video on the subject, as a result of the fact that many members of the cryptocurrency community are eagerly anticipating the conclusion of the lengthy legal dispute that has been going on between the United States Securities and Exchange Commission. Is in Ripple, it is possible that some external developments will have an impact on the outcome of the dispute as it happens. The Securities and Exchange Commission stud has also filed a lawsuit against Coinbase, a cryptocurrency trading platform. Coinbase, however, has replied to the SEC's lawsuit by filing a move to dismiss it in August 2023. Judge Catherine Filet heard the case on January 17, 2024, and her decision may have a big impact on the CC's case against Ripple. To be more specific, the Securities and Exchange Commission, as SEC asserts, that the proposed lending product that Coinbase is offering involves securities. Coinbase, on the other hand, dispute this as assertion and contend that it is not within the purview of the regulator. As a matter of fact, this is consistent with the charges that have been made concerning XRP, specifically that Ripple's efforts to sell it were classified as securities in the event that Coinbase prevails in the petition. It has the potential to weaken the SEC's claim regarding its jurisdiction over enterprises and assets in the cryptocurrency sector. Additionally, it may discourage the SEC from appealing the verdict in the Ripple case, which the regulator has indicated intends to appeal, owing to the parallels between the two instances. While this was going on, legal expert Bill Morgan made the decision to combat the moronic feud, which stands for fear, uncertainty, and doubt that has been causing the price of XRP to fall. He also decided to put the record straight by pointing out numerous significant issues, one of which was that a settlement is not even a possibility. It is possible that it is time for an update on what is actually taking place, given that the spread of false information regarding the SEC v. Ripple case has resumed. The situation is not going to be resolved anytime soon. A motion to force Ripple to release its financial statements for the years 2022 and 2023 was submitted by the Securities and Exchange Commission, CMI, January 11. A tweet from Bill Morgan, 1st of February 2024. In addition, he brought to people's attention the news that the Securities and Exchange Commission had submitted a motion to compel Ripple to open its 2022-23 books and post a complaint institutional contract. In response, the blockchain business responded by stating that the request was untimely and irrelevant, as reported by Fine Bold on January 26. Morgan had already accused the SEC of misleading the court by erroneously referencing the class action case of Zach and iRipple in its finance case. Thanks for watching till the end. See you in the next video. Love you all.